I think rather than going through any kind of overview of the trial, we should just address each argument and spell out the facts relevant to each of them. And the first, of course, is one of my favorite arguments in the world, and that's that you were deprived. Well, not, I'm not happy that you were deprived of it, but the ability to present a necessity defense to the jury. And Steffen, can you give us the overview regarding affirmative defenses in general and when they must be charged to the jury, and tell us about this particular defense as it is articulated in California law?
Yeah, so affirmative defenses, we're all familiar with, self-defense, these sort of paradigmatic examples in which even if you committed what ostensibly looks like a crime, you broke the car window of a car where there's a dog or a child who's suffering inside because of the heat, or you defended yourself using violence against someone because you were threatened. We believe in those kinds of emergency situations, you actually do have a defense. And not only do you have a defense, but you're justified in taking action. We want the person by the hot car to smash the window to save the dog or the child inside. We want the person who's threatened, whose life is threatened, to defend themselves. And so we have these affirmative defenses. And the affirmative defense that's most relevant here, as you mentioned, is necessity. I'm sure most of your listeners are already familiar with it, but just sort of in broad strokes, basically it says you can violate the letter of the law to avoid some greater evil. Again, the dog in the hot car is a perfect example. Ordinarily, you can't go around smashing car windows. If there's a dog, a child, some individual in the car who's suffering, then you actually can do that. And you have a defense available if you do that. And our argument here was basically that the exact same. It's that in this case, we knew for a fact that there were many, many animals suffering at these farms, especially at Sunrise, as Wayne mentioned. I mean, the documentation was extensive. There was footage that was just absolutely horrific to see. Wayne had been in even just the night before the rescue. And so we knew that there was evidence of animal cruelty happening inside, a really egregious animal cruelty. And so the basic idea is that a trespass to go into a farm and remove an animal and give that animal veterinary aid it's a fairly small sort of crime, all things considered, whereas the evil that we're averting, the evil of animal suffering, is much greater. And so as a result, you're justified in taking action. And the court ultimately denied the necessity defense, meaning that Wayne was not allowed to present evidence to the jury of necessity, wasn't able to present evidence of animal cruelty, wasn't able to present evidence of all the reporting that he had done to various agencies and law enforcement around California. I mean, ultimately, the jury also wasn't instructed on it. And what that means is that ordinarily a jury is told, look, you can acquit the defendant if you find these things, if you found that they acted in self-defense, or in this case, if they acted out of necessity. And the jury wasn't told that. And the reason is that the judge decided that as a matter of law, the necessity defense simply did not apply because in the judge's view, necessity does not apply to animals. And I'll pause there, but I think that sort of a patently ridiculous ruling, and we can dig into why.
Yeah, actually, I do want to dig into why. And I really wanted to know, did the court give any explanation? Because it does seem patently ridiculous to just eliminate a particular offense. Was there any rationale given, or was it just a ruling? No, it doesn't apply. We have that defense in California, which not every state does have that defense. It's not exactly on the books in California, but it's definitely a defense in California. Did the court articulate any reason as to why it doesn't apply to this particular? I think the language is significant evil. It applies to significant evils.
Correct, which I actually think is, again, California's necessity defense is in some ways much more expansive than many other states. It doesn't say just that there's a harm to a human being or to a person, and then we would get into difficult personal questions. It says significant evil. And I think it's very clear that suffering to animals is significant evil. It's criminalized in California. There's all these cases saying that it's a policy of California to avoid suffering to animals. There's all these ballot measures that have been passed. I mean, it's very clear that California law considers harm to animals a significant evil. But the court gave kind of these two sort of half-baked rationales. I'd say the primary rationale was just it's never been done before, which I think everyone recognizes is not a very good rationale.
I mean, a case of first impression, like you learn about that first year law school.
Exactly. So I think that's just it's a very bad rationale, but I think that was probably the sort of main motivating thing, was sort of like, I have to do something new here. I'm not going to do that. And as a result, I will do something what I think is sort of straight up illogical. And then the second rationale was this sort of weird slippery slope argument where I think she explicitly said something like, oh, if we extend it to animals, what's next? Are we going to have to extend it to, to cellular matter? And
what?
I'm not quite sure what she was going for there.
Oh my God.
My sense is that she didn't maybe fully understand the argument or what we were going for. I mean, I'm not quite sure. I mean, it was not exactly it's a bit hard to reconstruct charitably, to be honest. But again, that one's also ridiculous. The argument was that animals who are already recognized by California law to have a right not to suffer, that's simply the right that we're trying to vindicate here. It's already in California law. We're not asking her to write new laws or anything like that. Just apply the law as it is.
What I also think is relevant too in thinking about it is that the necessity defense, it doesn't say you can do anything you want if an animal is suffering. I mean, in the context of animal suffering, it's a balance between the evil you are doing by breaking the law and the evil that the law is meant to prevent. So if you're doing, if you're shooting somebody to save an animal, maybe that wouldn't be considered a necessity. You should have done something else to save the animal. So it is already a balancing act. It's not like animal cruelty or anything else just trumps what. Oh, shouldn't use that word. Whatever is on the other side. It's the balancing act that should go to the jury, right?
Right. So it's a fairly narrow defense. So first you have to have a significant evil. So not everything counts. Just because you've been pinched or hurt or something like that in a minor way, you might not be able to assert the necessity defense. So it has to be something significant, a significant evil. There also have to be no alternatives. You have to have exhausted all your alternatives. You can't simply go it alone if you haven't reached out to law enforcement or other people. It is the case that if reaching out is futile, you don't have to do that. And in these cases, we know that there's such a pattern of reporting. But in this case, there was a lot of reporting, right? So it's not the case that like Wayne saw something and just walked in immediately. There was all of this stuff beforehand to try to get the authorities to act, to try to get people to actually do the right thing. And when all else failed is when activists took action. So there's all these ways that it actually ends up being limited. And exactly like you said, there's also this sort of proportionality requirement, this kind of imminence. It has to be basically an emergency where you're taking action.
Yeah, the imminence requirement actually, that is an argument that they're still making on appeal. If the harm does have to be imminent, how do you address their argument that the fact that Wayne planned the events at issue ahead of time, that or somebody planned them, a lot of people planned them, and it wasn't done on the spur of the moment? How do you address that argument? That makes it not imminent.
Yeah, so I think just it's very clear that the harms were imminent because they were structural. It was about the nature of the facility, the scale of the facility, the number of animals inside. And also, once you have enough evidence, once you go inside and do these investigations, and every single time you go inside, you see widespread animal suffering due to these structural features of the farm, it's very clear that if you've done that 9 times, on the 10th time, it's not going to be surprising that you're going to see the exact same kind of suffering. So I think just because there's a plan involved on the front end doesn't mean that it's not an emergency. I mean, there's all sorts of when the fire department shows up to a house that's on fire, the fact that they first put on their gear and they hook up the hose and do all these things instead of just rushing in like mad doesn't mean that isn't an emergency. There's stuff that sort of take preparatory actions. I think the same is true here, where you have animals suffering. You need to make sure that you have veterinary help available, that you're actually able to get in and get the animals out and identify the animals in need. The people who go in have some understanding of animal health and animal care, know how to hold the animals, know how to identify an animal who's suffering, an animal who isn't suffering. So the fact that there's some sort of preparation on the front end, I don't think diminishes it by any means.
Yeah, otherwise it would eliminate so many areas in which really significant harm is being done. If the only way you could exercise it is to immediately try to address it without taking some precautions or preparing yourself for I mean, I think it's an argument that it's not like no court has ever decided this before. That's just, I don't know, it's ridiculous. Do they actually argue that on appeal?
Can I actually be a legal realist and add what other reason the
And
judge decided how she
you
decided?
always are.
I think
Oh
this
yeah, there's a lot
case,
of legal realism going on here. Even I am willing to admit that.
well, yeah, and I think this case is an example. It's a very abject example of how the law is read through the distortionary lens of power.
Yeah.
Because the Farm Bureau is incredibly powerful in Sonoma County. The Farm Bureau endorsed Judge Basalia and has enormous influence over the DA's office. And the owner of the farm, a multimillionaire who spent 6 figures fighting various ballot initiatives, Mike Weber, was treated like royalty in the courtroom. It was kind of shocking how contemptuous the judge and everyone in that courthouse was towards the animal rights activists, and how everyone just like stood out the red carpet for this guy. And I think part of the answer is, and we're seeing this around the country right now with, the First Amendment, the Second Amendment, how these principles often bend quite a bit when
Pretty
someone
fuzzy.
powerful
Yeah.
decides,
Yeah.
yeah, I mean, it's just the nature. And I think this is just one of the cold, hard realities of democracy and the rule of law that Americans are somewhat wising up to.
I think another area, I think this would be considered legal realism, but you can tell me because you're the expert in that. It also, all of our arguments prove too much. If what's happening to those chickens was illegal, it means everything that billions of animals are being treated illegally, cruelly in the United States. Like, what do you do with this? Everything we argue proves too much, doesn't make it untrue, but the implications are always daunting. And for judges, to step out of the box and do something that daunting takes a lot of courage.